That is, well, this affirmative and negative.
Even assuming that the governor had material to call for a trust vote. Now, what is the basis for picking up Shinde? We are 17 minutes past or 18 minutes closing. The governor had no material to. I think for a trust vote.
30 will close now.
There was no valid material at all.
No, Maharashtra, I'm asking, 3:30 is now, it's 3:20. I've done one out of my 7 points. This is a matter of some. I'm not going to conclude.
I mean,
I can't just go and conclude. It is very useful in when your lordship asks questions.
Your points are really alaps applies against him.
No, with respect. He quoted Bashir Bhadra to say, "Chup rahe to galat." One out of 8 points. I would not otherwise take time. And your lordship, it is not intended to stop your lordship's querying, because your queries are actually make us think.
All right, Dr.
The governor in his letter at 326
You're always very precise. Now go on to the next point.
Your lordship's compliment of a resolution render me speechless. I'm not going to be to exit the government.
No, it's not.
It doesn't exist at page
There's too
55
much.
of the
The
resolution.
point is, there is a lot
So he's
of
doing things.
stuff.
The resolution doesn't say that we are exiting the government.
Yes. So he heard something.
We had wanted to
summarize it for us.
Well, I found a more appropriate one. Speed along. Your lordship may give me a few minutes after. I am very keen to finish. I'm not till now. I'm not repeating a single point.
There was a valid exercise of power by the governor to call for a trust vote.
Let me end this first point by saying,
what happens if we come to the conclusion that there was no valid exercise of power by the governor to call a trust?
Everything falls. What happens in my first point of affirmative and negative?
Everything falls.
Your lordship I'll be dealing with my Malas. That's a good way of answering my Malas proposition. Your lordship saved a lot of unnecessary exercise. How does the lordship operate? Your lordship comes to the 4-step plus follows the 3-step, which in any case is the norm,
according to you,
and will be followed in every case to defeat the tension. Just straight away, let me just change my tack and go to Bombay.
But you resign, no?
No, that's I covered in my note directly. 5 reasons. Justice Shah asked me that in the beginning. Your lordship asked me that. I straight away answer. That is actually red herring. My resignation and not facing the trust vote is irrelevant.
This resignation trust vote will be careful.
No, I'll deal with it. Let me deal with
because
it is irrelevant for the following reasons.
It's like the court being told that you reinstate
just turn to para.
The reason why we are wrapping you up, so to speak, is not because you have no case.
No,
I asked you to wrap up only because now
plausible looking
on us to
show that in a minute.
apply our mind and step back and decide.
I think oral, yes, how can the court to speed up? Let me ask you para 14 of my note, A7.
Who did not even face this floor of test.
Your lordship will not reinstating anybody.
We've now got a...
Now I'm answering your lordship, yes. And should I had 6-7 heads, this is my second head more graphically. And it starts, this head starts at that is the meaning of a 6.
But Miss Dr. Singhvi, it would have been
starts
a
at para 9,
logical thing
page
to
6.
do. That's where we are, it would be a logical thing to do.
The act of
Provided you
resignation
had lost the trust vote on the floor of the
and would have no relevance to the reversal of the
because then clearly you have been ousted from power because of a trust vote which is set aside.
Duty bound to satisfaction, I believe, that the lordship recollects my A3 submissions, para A to N, which are repeated here.
That it's not that you have been ousted from power. As a result of
all that, I'm finishing off with one para. I'm not
summoned by the governor.
Just reminding your lordships.
You chose not
skip all that and come to para 14.
For whatever reason, you didn't want to face the trust vote.
As my lord, para 14, squarely, allow me, once the illegal act of the governor is allowed to be implemented, the result was a known and foregone conclusion. Straight away, your lordship, actually, there was no need for the ex-CM to subject himself to it. The most important thing is it's a prior challenge. If your lordship comes to the illegal act of the governor is a prior pending sub judice challenge. May I end the first part? Before the trust vote. That is well as this affirmative and negative code.
Yes, that you made only one called upon by the governor to face a trust vote.
I'm grateful. After I had filed a petition, after I had made it sub judice, and after I had said this is completely unknown to law, don't allow it to go on.
And you are frankly accepting the fact that 3:30 will close now. I think we have seen everything.
No, I'm asking. The consequence of that is known to me. 3:20. Now just I've done one out of my 7 points. This is a matter of some. I am not sure to
conclude. I mean,
I can't just go in. But it is a very useful in when your lordship asks questions.
Now your points are really alaps of your...
Because the governor did so by recognizing a faction of 34 legislators.
One out of 8 points. I would not otherwise take time. And your lordship, it is not intended to stop your lordship's query. Because how does my non-participation validate the act of the governor? Is the core question.
You are always very precise. Now go to the next point.
Your lordship's compliment is intended to render me speechless.
Already
I'm not going to be speechless.
Prior is important.
No, it's not.
There is too much.
Participation or absence of participation, ex-CM could
stuff
not
that we have to
possibly affect the
reflect on
prior
now.
illegality,
And we
which is
just
already
want to
subject.
maybe
Your Lordship will just
Now, as
rapid
an
fire
example,
for
summarize
if
it
one,
for
this is
us
very
so
important.
that you can
If
have
one
it.
were
Let
to
me
assume
speed along,
that
and
I had
Your Lordship may give
subjected
me a few
myself
minutes
to the
after
trust
4
vote.
minutes. See, I am very keen to finish.
The
I'm not.
ex-CM had
Till now, I
subjected
have not
himself on
repeated a
30th
single point. I've given
and
Lordship
lost.
facet.
Now not
And
interrupt
after
you. Go
losing
ahead.
challenge the
So, well,
trust
let
vote,
me end this
it
first
would
point by
make no
saying,
difference in law
let me
because the trust
end the
vote
first
was
point by
merely the
asking myself a
consequence of the
reverse
illegal
question.
act of the governor.
What
And the challenge would
happens
still
in my
relate to the
first
governor's
point of
actions and not to the
affirmative
trust
and
vote.
negative if your lordships were to accept their
D. It
interpretation?
is therefore obvious in
That's
law
a good way of
that the
answering my
consequence of an
proposition.
illegal act,
Namely, your
emphasis on
lordship will have
consequence,
nothing left in the
cannot
tenth
determine
schedule.
the
How does
legality
the
of that
lordship
act
operate?
or
Both
validate
the
it.
fourth step or the
Indeed,
three
it
step
could also be said
becomes
that
the
the
norm
petitioners having challenged the
and
core
will be followed
illegality
in
at the
every
base,
case to
namely
defeat
the governor's
tenth schedule.
actions,
That's my first
without
point.
any delay.
Second point on resignation. Did not even need to challenge the trust vote. I could have said it's nothing but a consequence.
Your Lordship also has
Similarly,
to
if
deduct
the
minutes
individual
till 2:20
illegal
by
actions are
minutes
broken
from
up
your Lordships.
and there are different interpretations, it is clear that for the purpose of legal validity,
Now
either
the
the
second
first
point.
act of the governor in calling for a
Just look
protest
at this,
or the subsequent act of
this
the governor in
resignation
inviting an
trust vote little
administrating oath,
carefully. I
the
have 3 or 4 answers.
participation or
It is
absence
irrelevant for the
of the
following
ex-CM
reasons.
has no relevance.
Well, it's
Now let's just go
turn
back
to
up,
para
Singhi, the
up,
reason why we are
kindly scroll up on this
wrapping you up, so to speak,
section. Come
is
to
not
para
because you have no case.
Well, it's-
We
no,
have
Manoj,
asked you to wrap up
sorry.
only because now the
Para,
burden
Manoj.
shifts
Now,
heavy on
there's
us
a second
to,
point.
as adjudicators,
The second
to
point,
apply
but
our
just one
mind
thing is
and
left here, Manoj.
step back
Para
and
nine.
uh,
Let me, Manoj, now
decide.
speed up.
Para 9.
I think, Manoj, oral things help, but to speed up, let me
I'm
ask
not
you
sure
to read
whether
para
A3,
14 of my
my
note,
submissions
A7.
A to N are
Giving
para
the law
14.
EBUs, meaningful, status
Just
quo ante,
formulate
scrambled
it for
egg,
us.
fait
Yes.
accompli,
The
all that is
formulation-
given with
we've
law,
now got
Manoj, in
a-
that.
When
Kindly, Manoj,
Manoj,
do me the favor
now
of
I'm
taking
answering
it
the
as having
second
stated
ठीक
here.
है, page 7.
I had
Now,
6,
Manoj,
7
number
heads.
10.
This is my second head.
Indeed, in Bomai, paras,
And it
etc.
starts,
given,
Manoj,
the
this head
overwhelming
starts
majority
at
of 9 judges made
page
it clear that the
6.
proclamation under President's rule under
Starts at para 9,
356, there are
page
2
6.
states involved, Manoj, Karnataka
Resignation.
and Meghalaya,
The
very
act of
important,
resignation.
Act of
is
resignation.
liable to be struck
The act
down
of
and the
resignation
dismissed
subsequently
government
on
is
29
fully
June would
entitled
not
to be
defeat and would have
restored
no
to
relevance
office.
to the reversal of the illegal
But that's
action
the
of the
only
governor
reason
of
we are not doing it
28/6.
because
Elections have been
and
happened
in
in the
accordance with
intervening
precedent, this honorable
Not
court
just
should
that, this is very
effectuate a
important.
real
This
and
has not been
meaningful
shown to your
remedy.
lordship. Just give me a
Now,
minute.
Manoj, your lordship recollects my
398
A3
and 5 judges out of
para
9
A to
states,
N,
5 which are repeated here.
First is Justice Balaz
I
Jeevan
argued
Reddy,
EBUs,
with
remedian,
Justice
fait accompli,
Agarwal. The
status quo ante, all
proclamation
that.
must
I'm
therefore be
finishing
held
off
to
with
be
one
not
para.
warranted
I'm
by
not
Article
arguing. I'm
350
just
outside
reminding you,
its
Lordship.
purview, cannot be said
Now,
that the
skip all
President
that and
was
come to Manoj,
satisfied
para
that the
14.
government of the state cannot
For
be
a
carried
minute.
on. The action
Does
was
my lord
mala
para
fide
14?
and unconstitutional. The
Once the
proclamation is
illegal act of the
accordingly
governor is
liable
allowed to be
struck
implemented,
down.
the result was a
And
known
we
and
would
foregone
have struck it
conclusion.
down.
Factually, there
But
was
for
no
the fact
need for the
that
ex-CM to
elections have
subject
since been
himself to
held
it.
and a
The
new
most important thing
assembly
is
has
it's
come
a
in. That's the
prior
only
challenge.
exception.
The
Today,
illegal
the
act of the
illegal
governor
government
is
is
a
running.
prior pending
There is
sub
no
judice
election.
challenge before the trust vote.
So you are really
and the person
saying that
who
Mr.
otherwise,
Uddhav
suppose the
Thackeray
lordship votes the
resigned
governor to
only
be bad.
because he was called upon by the
Then a
governor
person
to
not
face a
entitled to
trust
be
vote.
holding the
I'm
post.
grateful
Hold the post after I had filed a
How can
petition
Manoj,
of
all
all courts
courts
of
of
sub
Supreme Court
judice and
accept
after
such
I said
illegality?
this is completely unknown to law, don't allow it to go on.
Manoj, if your
And you are
lordship's
frankly
Manoj,
accepting the
your
fact
lordship's
that, well,
powers
you
are
resigned
unique in
because
this
the trust
country,
vote was
in
going
that
to go
even your
against.
lordship's
do an
can go
illegal act,
beyond the law.
Yeah.
The
Not contrary to law,
consequence of
beyond
that
the
is
law.
known to me. Then what's the point
just
if the
kindly
governor's
to
actions
save
are held
time,
to
let
be
me read.
illegal?
The
Actually, your
crux of
lordship
the
would
issue
be
raised in
giving
the
a
petition,
Pyrrhic declaration
lordship
and
has got 14
accepting
A,
that the illegality
14A
has
line.
borne the fruits of its
The crux
illegality
of the
and
issue
people have
raised by
enjoyed
the
it.
petitioner remains
Now
that
let's
the
just see next
direction to
one.
hold the
In
trust
state
vote
of
was an illegal
Meghalaya, it's
act
very interesting.
because the
For the other
governor did
states
so
in
by
Bombay,
recognizing a
para
faction of
12 of my
34
note.
legislators.
Again,
The
Manoj Justice
CM's
Reddy said,
participation or absence
but
of
for the fact
participation
that
would not
since the
dilute that
proclamation,
fundamental
fresh
illegality.
elections have been held to the assembly.
If it's
Suppose
illegal, it's
Meghalaya
illegal.
not had elections.
How
and
does
Karnataka
my
had
non-participation
they would have restored
validate
Meghalaya.
the act of the governor?
Is
He
the
would have
core
certainly
question.
issued the writ and directed
That's the
restoration.
correct
Justice
legal answer.
Sawant for himself
In
and
law,
Justice
since the
Kuldeep Singh,
illegality of
our
28 was
conclusion
already
may be
sub
summarized.
judice.
So
However, in
prior
view
is
of the fact that
important.
fresh
And
elections have
pending
been
in a
taken
court,
place and new
the
assemblies have been
participation or
constituted,
absence of
no relief is
participation
granted
ex-CM
consequent upon the
could
declaration.
not possibly affect the prior
Therefore,
illegality.
Manoj, which is already substituted.
This is now
as an example.
Point.
If
Now
one
comes to
page one were to assume
on
that I
189.
had subjected myself to the trust vote. The ex-CM had subjected himself on 30th and
What
lost.
is the point, Dr. Singhvi?
And after losing challenge,
a
the
very
trust vote,
strange argument was raised.
it would make no difference in law because the trust was
Regularization
the
and
consequence
validation
of the
by
illegal
189.
act of the governor.
Mr.
And
Salve
the challenge
argued
would
at
still
length.
relate
Mr.
to the
Mehta
governor's
also
actions
argued
and not to the trust vote.
189, I'm sorry to interrupt. What is 189?
No, page one.
Page one of my note. That is, Malas, the de facto doctrine that actions validated by the actual act
validated, which is challenged as illegal.
Indeed, it could
I
also
be
Malas,
said
how
that the petitioners
wrong this
having
can be
challenged
and how
the core
dangerous
illegality
it
at the base,
Give me just 2 minutes.
namely the governor's actions, without
The case
any
law
delay,
makes it clear, but
did
just
not
come to
even
the case
need
law
to
later.
challenge
Just give me
trust
2
vote.
minutes.
I could
Well,
have said
the
it's nothing but a
first
consequence.
important thing is
Similarly, if the
note
individual illegal actions are broken up
that
and there are different petitions, it is clear that for the purpose of legal validity, either the first act of the governor in calling for a protest or the subsequent act of the governor in inviting an administrating oath,
there are two kinds
the
of challenges.
participation or absence
One
of
is
the ex-CM has no
A
relevance.
challenge to the very validity of the act.
Now let's
Come
just
to
go
para
back
8,
up. Let's kindly scroll up on this section.
So I
Come to
challenge
para
a validity of an act. Let us say the Governor's Act.
No, I'm sorry.
Let me say
Para
competence of a legislation.
So this is the second point.
Let me say
Dr.
fundamental
Singh.
second point, but just one thing is left here.
Versus the
para 9.
eligibility of certain
Para
people
9.
to act under the act, to sit there and act.
I'm not troubling with A3.
Your lordship under 189
to
protects
N
the second, not the
law.
first. CBU's meaningful status quo ante.
If the governor's action is
scrambled
bad,
egg, fait accompli.
will
Will
189 ever
given with
protected
law,
laws?
Manus, in that? Kindly, Manus, do me the favor of treating it as having stated here.
Mr. Manus, friends, two of
number
them
10.
argued at great length on
Indeed,
189.
in Bomai,
Did they answer the
Paras
question?
etc.
Ultimately, the
The
core question, my lord, is
overwhelming
just formulated
majority of
either way,
nine
this way or
judges
that way.
that the
Is the
proclamation
governor
under
valid or not
President's
valid?
rule under
If your lordship
356,
holds him to be
there are two
invalid,
states involved, Karnataka and
189
Meghalaya,
comes
very
only
important,
after your lordship holds something
is
to be
liable
invalid.
to be struck down
Otherwise, doesn't come into
and
play.
the dismissed government is fully entitled to be restored to office.
So,
But the only reason we are not doing it because elections have been happened in the intervening period.
your lordship
Now, just this is very important. This has not been shown to your lordship. Just give me a minute.
in the intervening period of
398 and there's 5 judges out of 9
decisions
states. 5.
taken by an
First is
otherwise
Justice Wallace
illegally
Jeevan
constituted
Reddy
government may be valid
with
under
Justice
189.
Agarwal. The proclamation must
That's the
therefore
real
be held to
common
be not
sensical way
warranted
of
by Article
implementing it.
350 outside
I am
its
not
purview. Cannot
suggesting
be said
that somebody's
the
appointment is
was
squashed.
satisfied that the government
Somebody's
of the state
transfer is
cannot
gone.
be carried on.
Somebody's
The action was
policy
mala
is
fide and
Dr.
unconstitutional
Singh,
liquor policy.
Dr.
The
Singh, what is
proclamation is
saying is
accordingly
that
liable
Article
to be struck
189
down.
recognizes a
And
de
we
facto
would have
doctrine.
struck it
De
down.
facto doctrine.
But
What
for the
the de
fact
facto
that
doctrine does
elections have
is
since
to
been held and a new
legitimize
assembly has come in. That's the
the
only
acts
exception.
of a
Today, the
authority
illegal government is
whose
running.
original
There
appointment
is no
is
election.
found to be invalid.
Subsequently found to be
Subsequently found to
correct.
be
Then,
invalid.
Malus,
But
and
that
the
does not
person who
validate the
otherwise,
original
suppose the lordship
appointment
holds the
itself.
governor to be bad.
That's the one
Then a
sentence.
person
Prithi
not
summary.
entitled to
Just
be
give me a
holding the
minute.
post.
Come
Hold
to
the post
the
of Chief
8D.
Minister. How can, Malus, of all courts, the Supreme Court
8D.
accept such illegality? Malus, if your lordship's, Malus, your lordship's powers are unique in this country, in that even your lordship can go beyond the law. Not contrary to law, beyond the law. Then what's the point if the governor's actions are held
governor
to be
being
illegal?
approached, governor
Actually, your
calling.
lordship would be
The
giving
two
up
others are
correct
consequences.
declaration
Voting
and
is a
accepting
consequence of
that
the governor's illegal act.
illegality has borne
So
the
is the
fruits of its
oath
illegality
taking.
and people have
If
enjoyed
the
it.
original act is bad,
Now let's just see
and your
next
lordships
one.
can't validate
In
it,
state of
then
Meghalaya,
this will not validate the vote.
for the
The
other
consequence
state
is
in
bad.
Para
The
12 of my note.
consequence of an illegal
Again,
origin
Justice Reddy said,
cannot validate
but
the
for the
illegal
fact
origin.
that
Since the proclamation, fresh elections
and
have been held to
similarly,
the assemblies.
189
Suppose
cannot
Meghalaya
not
had
had elections and Karnataka had.
What you're saying is
They would have
that
restored in
in
Meghalaya.
the calling of
we would have certainly issued the
voting in the
directed
House
restoration.
itself is
Justice
subject
Sawant
to
for himself
Just now my
and
lord's
Justice
formulation
Kuldeep
was
Singh.
right or
Our
wrong.
conclusions
Governor's
may be
action. However, in view
no
of the fact
basis,
that fresh elections
and
have
B,
been
if
taking place
basis,
and new assemblies have
it
been
is wrongly
constituted,
applied, etc.
no relief is
that's
granted
affirmation
consequent
of the
upon the
House,
declaration.
right? Then I mean, I still have
Therefore,
the
Affirmation is coming.
This is
section.
Bomai dealt with the
heart
affirmation.
of this point.
All right.
Now come to
Bomai
said,
page
we
1
hold something to be
on
illegal.
189.
Let's
The
kindly
third
give me a
point
minute,
is
this very
189.
interesting. But thereafter, Parliament is approved it.
That is coming
Exactly the
separately.
same thing. How can
What
we
is the
caution?
point, Dr. Singhvi?
Yes.
Said no, sorry.
Now, there was a very
Will be
strange
cautioned.
argument was
And come
raised.
to that de facto doctrine. So
Regularization and validation by
Yes,
189.
I'll just show it.
Mr. Salve argued at length. Mr. Mehta also argued, I
Page
believe.
189, I'm sorry to interrupt. What is
Sima's query
189
answered by
here?
Bomai.
page one.
Para
Page
4
one
of my note. This note. That is, Wallace, the de facto doctrine that actions validated
Much worse,
by the
Wallace.
actual act.
Here there was nothing in our
which is
case, there
challenged
nothing.
is illegal.
Here there was a
I want to show Wallace
presidential
how
proclamation
wrong this can be and how dangerous it is.
affirmed by
Give me just 2
Parliament
minutes.
in Bomai.
The case law makes it
Now
clear.
come
But
to
just
Wallace
come to the
para
case law later.
4.
Just give me 2
It
minutes.
is respectfully submitted
Well,
that
the
said
first
contention
important
misconceived
thing
liable to be
is
rejected in Bomai.
to note
Does my lord have it? Para 4.
That
Do my lords have it?
Yes.
Yes.
Considered the effect of approval of a presidential proclamation by both houses on the legal validity of the proclamation.
there
when
are
it is
two
questioned
kinds of
before the
challenges.
Constitutional Court held a clear majority,
is
5 judges,
a challenge
that if
to
a
the very
proclamation
validity of
is
the act.
invalid,
Come to para
the
8
same
of my
as
note.
liable to be set aside even if it has been subsequently approved by
I
both houses.
challenge,
The
Manoj,
lordship is
a
told
validity
289,
of an act.
189.
Let us say the Governor's
This is
Act.
express approval. Let me say
This is express
competence of a
approval.
legislation.
Now read this para. Very
Let me say
interesting.
fundamental rights. 110
Versus
Justice Sawant
the
for Justice
eligibility
Kuldeep
of
Singh.
certain
This
people
we
to
got the
act under
point.
the act.
You're saying that
To
the
sit
Bomai
there
has
and
it.
act. Now there is one interesting,
Your
very
lordship
interesting,
under
after
189 protects
29
the
years
second, not
and
the
2
first.
days. This is happening in a lordship's
If the
court.
governor's action
This
is
para
bad,
110. Will 189 ever protect it?
that bold-face line by Justice Sawant
Mr.
says invalid.
Manoj, friends, two
Lordship
of
got
them
the second
argued
line
great length on
underlined.
189. Did they answer the
Yes.
question?
All
Ultimately, the books, question, my lord, is just formulated either way, this way or that way. Is the governor valid or not valid? If your lordship holds them to be invalid, 189 comes
SCC
only
for
after your
29
lordship
years
holds something to be
and
invalid.
2 days called
Otherwise,
it
they'll
valid.
come into play.
I hope you are citing our ESCR, Dr. Singh.
No, this is, we've checked up. Then they issued
So,
a corrigendum.
when my learned friends
Exactly.
colleague here,
Therefore,
sitting here,
no, no,
pointed it out,
Then
your
one is
lordships
the
can
SCC
Dr.
issued a
Singh,
corrigendum.
in this
I
case,
must
perhaps
also
should.
publicly
In the
acknowledge
intervening period of
there
7
was a
8
glitch
months,
in our
the decisions taken by an
ICT,
otherwise illegally
ICT
constituted
infrastructure
government may be
overnight.
valid under 189.
My team was working till
That's the real
5:30 in the
commonsensical
morning.
way of
They
implementing
began
it.
working
I am not
yesterday.
suggesting that somebody's appointment
They
is
left
squashed,
for their homes at 5
somebody's
o'clock in the
transfer
morning,
is gone,
5:30 in the morning.
somebody's policy
To
decision.
ensure that
Maharashtra
we are
government made a
all,
liquor policy,
Dr.
therefore
Singh,
that is
what you're
gone.
saying is
We are
Article
ICT
189
enabled.
recognizes a de facto
Very
doctrine.
creditable. De
And
facto
unlike the
doctrine.
private sector, they
What the
wouldn't
de
get
facto
even a rupee
doctrine
worth
does
of
is to
just a love for the
legitimize
job that they do.
the acts of an authority
Your lordships,
whose
that
original
is
appointment
right.
is found to be invalid.
Subsequently found to be
Subsequently
You
found
are
to be invalid. But that does not validate the original appointment
That's
itself.
the just
No,
that's
this is
the
just
one
a aside.
sentence pithy
The word
summary.
in
Just give me a
private
minute.
sector
Come
or
to
senior
D,
counsels, I
8D.
Chief is saying
8D.
Some of your lordships, most of your lordships.
I told my learned brother, you are
Stop.
part of them too.
Complete estoppel, Willis.
Estoppel, that's why I didn't say.
And a
Or
very recent estoppel,
calling
relatively.
for that goes back to the
Now,
same
Willis,
thing.
the word
First
invalid
act was
here
what?
is by a
The governor
corrigendum,
being approached,
the
governor
correct
calling.
word.
It is in
The
the
two
SCC
other
valid.
consequences.
It can't be
Voting is
valid.
a consequence of the governor's illegal act.
What is the
So
legal
the
oath
consequence of
taking?
actions taken by
If
the
the original
president,
act
if
is
the
bad,
proclamation is
and your
invalid,
lordships can't
yet it is
validate
approved
it,
by both houses.
then this
Come
will
to
not
111
validate the vote.
lordships, see, I am
The
racing only
consequence
on
is
the
bad.
underlined portions.
The
The
consequence
proclamation
of an
will not
illegal
make any
origin
difference to the legal
cannot
status.
validate the
Express
illegal
rule.
origin.
Forget 189. Parliament
And
expressly
similarly,
approved.
189 cannot
The action will undoubtedly
What
be
you're
illegal.
saying
Then we'll
is
skip
that
10 lines.
if the
There is no
calling
reason
of
why the Council of Ministers and the
voting
Legislative
in the
Assembly
House
should not
itself
stand
is subject
restored
to the-
Just now
as
my
a
lord's
consequence of the
formulation was
invalidation
right
of
or
the
wrong.
proclamation, the
Governor's
same being the
action,
normal legal
A,
effect
no
of the invalid
basis,
action.
and
In
B,
the
if
context of
basis,
constitutional
well,
provision
it
which
is
we have
wrongly
discussed,
applied,
and in
etc.
view of the
But
power
that's
of
the
judicial
affirmation
review
of the
vested in the
House,
court,
right? Then
such a consequence is
still
also a
have the
necessary
affirmation is coming.
constitutional fallout.
This section.
Necessary
Bombay dealt with the
constitutional fallout.
Get the point.
Unless
Bombay
the result
said,
is read, the
we
power
hold
of
something
judicial
to be
review is
illegal.
due. You get to
That's
the
kindly give me a
meaningless.
minute. This is very
There is
interesting.
a constitutional
But thereafter Parliament has approved it. Exactly the same thing.
permissible to have a
How can
complete
we caution?
restitution is what you're saying.
Otherwise,
No,
it's
sorry.
meaningless and
Will be
nugatory. The
cautioned.
9 judges
Shall
say
come to
that,
that
and next sentence highlighted. Hence, the necessary
first let us come
consequence
to-
of the
yes,
invalidation
I just should repeat.
would be the
Just keep things
restoration of the ministry as well as the Legislative Assembly.
Sima's
Then
query
para
answered by
114,
Bombay. Para 4 of my note.
boldface.
This note.
Secondly, the court may invalidate the proclamation whether it is approved by Parliament or not. The necessary
Much worse,
consequence of the
fellas.
invalidation.
Here there was
could
nothing
be
in
to
our
restore
case,
the
nothing.
status
There
quo
was a
ante.
presidential
Therefore, to restore
proclamation
the Council of Ministers, the Legislative Assembly,
affirmed
as
by
they
Parliament
stood on the issuance of the
in Bombay.
proclamation. So if your
Now
lordship
come
is
to
otherwise
para, convinced your
Fourth,
lordship needs
it
no
is
support than
respectfully
more than a
submitted that
9-judge
the said
bench,
contention is
which is
misconceived,
very
liable
clear.
to be rejected in Bombay.
Does my lord
It
have
may,
it? Para
however,
4.
to be made clear. Next sentence
Do
very
my lords
formal.
have it?
Next boldface.
Yes.
It is, however, to be made clear.
Considered
that
the
effect of
interlocutory
approval of a
granted
presidential
such challenge to
proclamation by
prevent
both
frustration
houses
of the
on the
remedy.
legal validity
It is not
of
to
the
prevent the
proclamation when it is
constitutional
questioned
before the
exercising its
Constitutional
powers
Court
with
and
clear
discharging its
majority,
function.
5 judges, fellas,
And then to
that
conclude,
if
the
a
court in
proclamation
appropriate
of
cases
is
not only
invalid,
justified in
the
preventing
same
holding of
is
fresh
liable
elections,
to be set
but would be
aside
duty
even
bound
if
to
it
do
has
so
been
by granting
subsequently
suitable
approved by
intervention.
both houses. Your lordship is
Then
told
they
289,
summarize the
189.
conclusions,
This is express
which I will
approval.
not read to save time.
This is express approval.
Clearly,
Now
Maharaj,
read this para. Very
para
interesting.
after para is devoted by Justice Sawant and
110,
Justice
Justice Sawant for Justice Kuldeep
We'll
Singh.
check this up. We got the
Well,
point.
Justice
But you're
7,
saying that the
another
Bombay
phrase,
has a...
molding of
Now
relief.
there is one
Big
interesting,
Roman 7.
very interesting. After
Well, otherwise,
29
what's the
years
point your
and
lordship
2
is
days,
exerting so much? Well,
this
if your
is
lordship
happening in
comes
your
to that
lordship's court.
conclusion.
This
With
para
great respect.
110.
And that to a
That
court with
bold
141,
face
142
line
special
by
powers.
Justice
I can
Sawant
understand the High Court
says
possibly was
invalid.
flinching.
Lordship got the second
Why
line
do we even the High Court
underlined.
has the power to do it under your lordship's judgment?
Yes.
All the
Now,
books,
Justice
fellows, say
Jeevan
it's
Reddy
valid.
said
this, fellows. Even in case the proclamation is
SCC.
approved, it would be open to
SCR
the court to
correctly
restore the
says it's
state
invalid.
government to its power. If this
SCC
were not
for
conceded,
29 years
look at these words,
and
fellows.
2 days
9
called
judges.
it valid.
I hope you are
29 years
citing our
ago.
ESCR, Dr. Singh.
If this were
No,
not
no,
the case,
this-
the
we've
very
checked up.
power
Then they
of
issued a
judicial review
corrigendum.
rendered
When my
nugatory,
learned friends
entire
calling
excise
here, sitting
meaningless.
here,
The
pointed
court
it
cannot
out.
grant the relief flowing
Then
from the
Maharaj,
invalidation.
the
It
SCC
may well
issued a declined to entertain.
I must
Well, they say
also
if you can't
publicly
grant the relief,
acknowledge
why did you
there's a
entertain?
glitch in our
That's what this court is saying, 9 judges.
in our ICT infrastructure overnight.
And then
My
Justice
team was
Pandyan,
working till
just 2
5:30
lines
in the morning. They began
above 4
working
a.m.
yesterday.
I find myself in agreement with
They
the
left
opinion
for
of
their
Justice
homes at
P.B.
5
Samant
o'clock in the morning,
on conclusions
5:30 in the
1,
morning,
2, 4
to
to
ensure
8.
that we are all
This includes my conclusions,
we
which I
are
just read.
ICT
4 to 8.
enabled.
Very
So
creditable.
this is
And
one of
unlike the
the
private sector, they wouldn't get even a rupee worth of.
3 points are covered.
It's just a love for the job that they do.
189 and resignation.
Your Lordship's
Now, the fourth point is this
Uddhav.
prospective and
You were
retrospective
part
of
of
the
them.
EC. They're all important queries which fell from my Lord. My Lord, the Chief Justice asked this question
No,
more
this
than
is
once.
just an aside. The
I'm
word
saying private sector or senior counsel.
That is my C, my Lord is right.
some of your lordships, most of your
Just
I
lordships.
told my learned
forget
brother you
everything
are
else.
part of them
I'll
too.
take one point here is enough.
Whatever else the Lordship
And a very
holds,
recent
on the
estoppel,
bare
relatively.
text, textually and facially.
Now, the word invalid here,
Symbol order number
is by
5, 15.
corrigendum, the correct word.
Has to be
it is in the
prospective,
SCC
Manoj.
valid. Forget all the,
It can't
come
be
to the
valid. Just note
interpretation. Just read the text.
What is the legal
facially.
consequence of
That's at
actions
para
taken by the
15A
President
of
if
my
the
note.
proclamation is invalid?
Yes.
yet
Without
it is
anything
approved by
more.
both houses? Come to
We'll come to the consequences.
See, I'm racing only on the underlying portion.
As drafted,
The proclamation
facially,
will not make any
without any
difference to the legal
interpretation.
status.
It has to be
Express
only
approval.
prospective. Kindly read.
Forget 189.
Power
Parliament
of the
expressly
Commission in
approves.
relation to splinter
The
groups.
action will
Now,
undoubtedly
I've
be
underlined
illegal.
some words.
Then
I've taken the
skip 10
liberty of
lines.
underlining some words.
There is no reason why
When
the Council of Ministers
and the Legislative Assembly
The Commission
should not
is
stand
satisfied
restored as
on
a consequence
information
of
on
the
its
invalidation of the proclamation,
there
the
are
same being the normal
rival-
legal
that
effect of the
there
invalid
are
action.
rival
In the
sections or
context of
groups of
constitutional
recognized
provision which we have
political
discussed,
party,
and in view of
each
the
of
power
whom
of judicial
claims to
review
be
vested
that
in the
party.
court, such
The
a
Commission
consequence is
may,
also a necessarily
after
constitutional
taking into
fallout.
account all the
Necessary
available
constitutional
facts and
fallout.
circumstances.
Get the point.
Unless such result
And
is read, the
hearing
power of
such
judicial
reps
review is
of the
nugatory and
sections of
meaningless.
There is a
and other persons who desire to be heard
constitutional,
decide
it's permissible
that
to
one
have a
such
complete
rival
restitution,
section or
is what
group
you're
or
saying.
none
Otherwise,
of
it's
such rival
meaningless and
groups
nugatory. The
shall
9
be
judges say
binding.
that, and next
Well, this
sentence
cannot but be
highlighted.
future.
Hence, the necessary consequence of the invalidation
Number
would be
two,
the restoration
look at
of the
consequences
ministry
of holding
as well as the Legislative Assembly.
strange consequence.
Then para 114.
Two things, fellows.
Boldface.
If your
Secondly, the
lordship
court
were
may
to
invalidate
hold
the
the
proclamation,
19th
whether it
July,
is approved by
that's
Parliament or not, the necessary
order of the
consequence
EC.
of the invalidation could be to restore the status quo ante.
Sorry,
Therefore, to
17th
restore
February
the Council of Ministers of the
23.
Legislative Assembly
77.
as they
Petition is
stood
filed
on
on
the
19th
issuance of the
July.
proclamation.
17th
So, if your
February is
lordship
the
is
order.
otherwise convinced, your
Now,
lordship
the
needs
order
no support than more than a 9 judge bench.
retroactive, which is very
Question
clear.
number 1, retroactive from when?
It may, how it to be made clear, next sentence is very important, next boldface. It is how
There
it
are
to be made
three
clear
possibility
that the interlocutory
retrospectivities.
relief that may be granted on such
Look at the
challenge to prevent
consequence, whether the
frustration
lordship
of the
doesn't
constitutional
hold it
review.
to be without
It
the
is not to
consequence.
prevent the constitutional
One
authority from
is,
exercising its powers and
it is
discharging its
retroactive
functions.
from the date
And
the
then
Shiva
to
Sena
conclude, the
was
court in
recognized
appropriate
as
cases
a
not only justified
29A
in preventing
political
holding
party.
of fresh elections, but would be duty bound to
That
do
is
so by granting
1990
suitable interim relief.
or 92.
Then, Malas, they summarize the
I'll give you three
conclusions,
alternatives.
which I will not read to save time.
Because today I am the
Clearly,
Election
Malas,
Commission, I
para
hold
after
that
para
this
is
is the
devoted
Shiva
by
Sena.
Justice Sawant and
If
Justice
it is
Kuldeep.
retroactive, logically it should go to the date
And
when 29A.
Malas, just see 7,
But let's leave
another
that.
phrase, molding
Second,
of belief. Big Roman 7.
it goes back to
Well,
21st
otherwise, what's
June,
the point your lordship
when this
is
action
exerting so much,
started,
if your lordship comes to that conclusion? With great respect.
and third,
And
goes
that
to
to a
19
court with
July when the
141,
petition was
142 and special powers, Malas. I can understand the High Court possibly
There are only three
flinching.
possibilities, Malas.
According
In
to me, the
all
High
of
Court has the
these,
power to do it.
the consequences would be
Now, Malas, Justice
that
Jeevan Reddy
Malas,
said this, Malas,
actually
even in case the proclamation is approved, it would
everything
be open to the court
I
to
would
restore
be
the state
guilty, but
government to its power.
I am actually
If this were not conceded, look at these words, fellas.
people who
9
have
judges.
remained
29 years ago.
Mr. Thackeray.
If this were not the case, the very
Just using
power
the
of
phrase with
judicial
no other
review
phrase
rendered
available,
nugatory,
and people who have
entire
left.
exercise meaningless.
Now,
The court
the
cannot
people
grant the
who have
relief
followed
followed
the
the
10th
invalidation.
schedule
It
and
may well
remained with Mr.
decline to
Thackeray
entertain. Well, they say if you can't grant the
would be
relief,
actually liable
why
for
did you entertain?
disqualification.
If your
That's what
lordship
this court
relates
is
back
saying,
there.
9 judges. So your lordship
And
would be
then
giving a
Justice
premium to those
Pandyan,
who follow the 10th
just 2
schedule and the
lines.
people who have not followed the 10th schedule.
Above 4A, I find myself in
protect
agreement
their
with the opinion of
disqualification
Justice
also
P.B.
and
Samant
disqualify me also.
on conclusions 1, 2, 4 to 8. This includes my conclusions, Malas, which I just
the
read.
inevitable
4
consequence
to 8.
by Malas. Of course, your lordship's words.
So
can
this
always
is,
be
Malas, that's the logical consequence of retroactivity. 3 points are covered.
They would make an arc of immunity for their
189
own
and Malas
disqualification
resignation.
and actually be liable because
Now, Malas, the
the
fourth
party
point
from
is
19th
this
July,
Malas prospective
any
and
whip, any order,
retrospective of the
everything.
EC.
I have violated.
They're all important
Because I'm not
queries
the party
for
from
my lord.
19th
My
July.
lord Chief Justice asked this question more than once. Malas. And therefore,
That is
Malas,
C.
I am liable to something. That is, Malas, my
from
C.
actually
My lord,
logically
right?
speaking
Pages
from the
8,
original
10.
Page 8.
Just
Therefore,
Malas, forget everything else. I'll take one point here is enough.
And
Malas,
Malas,
whatever
it would
else the
have the
lordship
strange
holds
effect of
on
the
the
election
bare
of Mr. Uddhav
text,
Thackeray in
textually and facially.
2018.
Symbol
will also
order
go.
number 5, 15. Without there
Has
being a
to be
fresh election
prospective,
unseating
Malas.
him. Forget all the, we'll come to the interpretation. Just read the
Everything
text.
will go, Malas.
Facially.
That's
No
it, para
adjudication by the
15A of
mere
my
act
note.
of recognition relating back
Yes.
without anything
Either
more.
to 1990s
We'll come to the
or
consequences.
2000 and,
Malas,
19th of
the-
July
as
or
drafted,
23.
facially,
Malas, I mean,
without any
21st of
interpretation.
June.
It has to
So
be
there
only
would be
prospective.
chaos.
Power of the Commission in
consequences,
relation
Malas,
to
are-
splinter groups. Now, I've
And
underlined some
apart from
words,
the
I've
fact
taken the
that
liberty
this
of
is
underlining some
clearly
words.
textually
When
not Malas intended by the
the
symbols
Commission
order.
is satisfied on information on his possession that there are
The fourth and the
rival, that
under
there
this
are
head, I'm not on the
rival
next one,
sections
under
or
this head.
groups of a recognized
It would
political
also
party,
destroy,
each
not
of whom
collateral
claims
damage,
to be
but
that
major
party.
direct damage.
The commission
It would
may,
destroy
after
the
taking
relating
into
back which
account
is held
all
by
the
a lordship
available
Rajendra
facts
Rana.
and circumstances,
Note this well, note
and
this.
hearing
Not a
such
single
reps
judgment
of
even
the
of any
sections
high
or
court, leave
groups
aside Supreme Court
and
says
other persons
that
who
the
desire
election
to be
commission
heard
will relate
decide that one such rival section
A
or group or
constitution
none
bench
of
has
such
held the
rival
field for
groups
very long
shall
saying
be
a
binding.
disqualification
This
claim
cannot
schedule
but
order
be
relates
future.
back. If your
Number
lordship
two,
were today,
look at
do
the
this,
consequences of holding otherwise.
your lordship
Everyone
was
is
very, very
strange
primacy
consequences.
to an order under a
Two things,
symbols
fellows.
order.
If your lordship were
With
to hold
any
the
judicial
19th
precedent
July,
not
that's
saying
it,
so,
versus
order
a
of the EC.
constitutional provision already held by a constitution bench to relate
Sorry,
back.
17th
And your
February
lordships cannot
2023.
reconcile
I'm
a
sorry.
relation back of disqualification.
Petition is filed on
with the
19th
relation
July.
back of the EC.
17th February
Can't
is
be
the order.
reconciled. Now, Malas, the order
Today, Malas,
to be
suppose
retroactive
tomorrow,
the
question
speaker
number one,
disqualifies
retroactive
Mr.
from
ABC.
when?
It is common ground by Rajendra Rana and many other cases. It relates back
There
to
are three
Malas,
possibility
June
retrospectively.
22.
Look at the consequence. Whether the lordship doesn't
But
hold
there
it to
cannot
be
be
without the
disqualification
consequence.
because by then your lordship
One is,
also would be applying.
it is
EC order.
retroactive from the date the Shiv
Retroactively.
Sena was recognized as a 29A political party.
Therefore, Malas, your lordship
That is
already has
1990.
jurisprudence and
Or
a
92.
precedent.
Prospective, according to you.
I'm giving you three alternatives.
Then, Malas, the fifth.
Because today
aspect
I am the election
is this
commission, I
political
hold
party
that
and
this is
legislative
the
party.
Shiv Sena.
If it is retroactive,
Dr.
logically
Singh, now
it should
5
go to the
minutes
date
now.
when
We will
29A. Finish before
But let's read that.
He will,
Second,
within this time, we'll finish. We are conscious
it
of that.
goes back to 21st June.
3:45 minutes, we'll finish
this
in that
action
time. I'll give him
started.
5 minutes also. He'll have 5 minutes.
And third,
Now, Malas,
it
F
goes to
is a
19th
very
July when the
important
petition
part.
was filed.
Actually, it goes to the root. This is the political party
There are only
versus
three
legislative party
possibilities,
debate, but from an
In
angle
all
different
of
than
these,
Mr. Sibbal.
the consequences would be
This is very well
that Malas, actually everything
Kindly
I
let us
would be
read this from
guilty,
a
but
different
I am
F,
actually,
right?
Yes, F.
I mean
Starting para
people who
35.
have remained
Page 12.
with Mr. Thackeray. I'm just using a phrase because there's no other phrase available. And people
Well,
who
as
have left.
members of a
Now,
legislature
the
party
people who have
do
followed
not
the
have
10th
any right
schedule
to act
and
contrary to
remained
the
with Mr.
directions
Thackeray
of their political party.
would be
This
actually
is the heart of
liable
the
for
political party,
disqualification.
legislative party
If your lordship
debate,
relates back
with
that.
which Mr. Malas call also started today at 2 o'clock.
So your lordship would be
As
giving
per
a premium to those who follow the 10th
194.1,
schedule and
the
the people who
freedom
have
of
not
speech
followed
is
the 10th
subject
schedule
to the provisions. I pointed it out already.
will protect their
Under
disqualification also
170
and
bracket
disqualify
1,
me also.
the assembly of a state consists of members.
Whereas your
The
lordships
members are elected
will
by
not
direct
avoid the
election
inevitable
from
consequence.
territorial
Of course, your
constituencies,
lordships' words can
and the
always
nature of the
but
election
that's the
process is
logical
such
consequence of
that an
retroactivity.
elected member set up by a political
They
party
would
has
make an
no
arc of immunity
independent
for their own
identity in the House
disqualification
except
and
as a
actually be
member of the
liable
political
because
party.
the party from
Actually, in
19th
practice,
July,
how we sit,
any whip, any order,
where we
everything,
sit,
I have violated.
which rooms we are
Because I'm
given,
not the party from
is
19th
all
July.
based on the collectivity of a party. Not in
And therefore,
suppose a
I'm
member
liable to
is
something.
the leader of a party, he is very,
Or
very
from
senior.
actually, logically
But
speaking,
that
from
party
the
has
original.
only 3 seats. Therefore,
And
another
this-
party with yesterday's first-time member, but the party is large number.
And
Seats are allocated, rows are allocated, rooms are allocated only on the basis of party.
in
That's how it has to be.
2018.
Could also go prior to introduction,
Without there
this is
being a
very,
fresh
very
election
important.
unseating
Just
him.
kindly see this. This evolution has been forgotten.
Everything
in this
will go,
argument
Manas.
of political party and
No
and legislative
adjudication.
party.
By the mere act of
Prior to
recognition
the 10th
relating
schedule,
back
prior to 85,
either to
the
1990s
Constitution
or
did
to
not
2000
mention
and
political party
19th
anywhere.
of July
Although
or to 23.
in parliamentary democracy, the heart,
I mean,
as your
21st
lordship
of
has
June,
in the English books,
there would be
is political
chaos.
party. Westminster model is political party.
Consequences,
Even though
are-
political parties were always recognized to
And
be an
apart from the
essential
fact,
component
this
of the
is
Westminster
clearly
form of
textually
parliamentary government.
not what was intended by
Political
the
party
symbols
as a
order.
term was defined for the purpose of election law in para
The
2H
fourth and the
of
last,
the symbols
under this
order.
head, I'm not on the next one,
Thereafter,
under this
through
head,
amendments,
it would
the
also
ROPA,
destroy,
Representation
not
of
collateral
People's
damage,
Act,
Manoj, major
whereas
direct
put
damage.
political party.
It
These are
would
the two
destroy
statutory levels.
the relating back
It
which
came
is
in
held by the
Manas
Lordship of
for the
Rajendra Rana.
first time with the
Note this well, note this.
10th schedule, which is a
Not a
constitutional
single judgment given of any
recognition
high court,
political
leave aside
parties.
Supreme Court.
And today,
says
our lordship has been asked
that
to
the
negate
election
that
commission will
recognition.
relate back.
Next para. On the other hand,
A constitution bench has held the field for very long, saying
legal
a
or statutory
disqualification 10th schedule order
basis. A
relates back.
legislature party by its very nature is not a permanent association of
lordship were
persons.
today
Its
to
life
do
is
this,
coterminous with the term of the House. The
your
very
lordship
coming
would be
into
doing
existence of a
primacy
legislature
to a
party is
order
dependent
under
on a
a symbols
contingency.
order.
The success of more than one or
With
more
any
than one candidate
judicial
belonging to a
precedent not
political
saying
party.
so, versus
The
a
10th
constitutional
schedule
provision already
defines
held by a
a
constitution
legislature
bench to
party
relate
in
back.
terms of a
And your
political
lordships
party. Cannot reconcile a relation back of disqualification
fellows,
with
conclusive,
the
I
relation
say.
back of the EC.
According to me, I may be wrong.
It can't be reconciled.
Conclusive.
Legislature
Malas,
party is
suppose
defined
tomorrow
in terms of the political
the speaker
party.
disqualifies Mr.
I've quoted
ABC.
the definition.
It is common ground by
And
Rajendra
Malas,
Rana
your
and many
lordship
other
is
cases.
concerned
It
with the
relates
whip.
back to Malas,
Whip is
June
peculiarly
23,
a political party activity.
But there cannot be
I'm
disqualification because
41.
by then your
The
lordship
purpose
will
of
also be
defining the
applying
group of
a
members
EC
of the
order
House belonging to one political party
retroactively.
as a legislature party can be gathered from the number of times
Therefore,
when
Manas,
legislature party
your
is
lordship
used.
already has
First in
jurisprudence 2:1 it
and
says a member of a house belonging to any political party.
Then,
What does it mean? Do you have an existence or identity other than the political party? After constitutional amendment and definition?
We will finish before
Then,
lordship's time.
there is no mention of legislature party in para 2.
3:45.
None.
We'll finish it in time. I'll give him 5 minutes also.
In
He'll
para
have
2, political parties
5 minutes.
mentioned.
Now, Malas,
Thus,
F
while
is a very
referring to
important
individual
part.
members, the
Actually,
10th
it goes
schedule
to the
refers
root.
to them as
This is the
political party to which they belong and not relation to legislative party.
but from an angle different
The
than Mr.
only
Sibbal.
place in the 10th schedule where
This
the
is very
term
well-
legislature party is used was either para 3 now gone or para 4.
Kindly, Malas, read this from a different perspective.
F,
In
right?
para 3, the
Yes,
term
F.
legislature party
Starting
was
para
used with the
35,
fraction of 1/3.
Page
Goes
12.
balance. In para 4-2, it is for merger. Doesn't arise in this case.
Malas, members of a
Doesn't
legislative
arise in
party
this case.
do not
Thus,
have any
wherever
right
the
to
10th
act
schedule
contrary
provides
to the
protection to a
directions of
group
their
of
political
legislators
party.
when acting as a
This is
group,
the heart of the
it uses
political
the term
party, legislative party debate.
Otherwise,
which
it's
Mr.
described with reference to
Malas,
political
call also
party.
started today
Now,
at
what is
2
the
o'clock.
consequence? This is a little important.
As per
The constitutional secretary of
194(1),
this
the
discussion
freedom
is
of speech is
that a
subject to
majority
the
faction
prohibition,
legislative
as
party
pointed out already.
has no constitutional
Under
identity
170
except for the
bracket 1,
purpose of setting up a
the
defense
assembly of a
under
state
4.
consists of members.
This is
The
important.
members are elected by
Today,
direct
there is no
elections from
status
territorial
identity of a
constituencies,
legislature party
and the nature
except
of
for
the
the
election
defense of
process is
merger.
such that an elected member
That's
set
all.
up by a
And
political
admittedly,
party
that's not your
has
case.
no independent identity
If
in the
no
House
defense is
except
claimed,
as a
the
member of the
legislature
political
party
party.
has no constitutional
Actually, in
legal
practice,
relevance is para
how we
43.
sit, where we
Therefore,
sit,
the group of
which
legislators
rooms we are given
belonging to a
is
political
all
party
based on
can
the
have no
collectivity
right
of a
of dissent
party.
or conscience.
Not an
This
individual.
dissent
Suppose a
argument.
member, the
Dissent
leader of
has
a
to be
party
within
is
the
very, very
parameters
senior,
of
but
what
that party is only
10th
3
schedule
seats.
allows you.
And another
Dissent
party
cannot
with
say, I'll
yesterday's
over,
first-time member,
broad
but the
basis
party
for
is large
to
number.
act or give any
Seats
judgment
are
on.
allocated, rows are
Dissent.
allocated, rooms are
I
allocated.
just say
only
I'm
based on party.
dissenting and I leave the 10th schedule.
That's the way it has to be. Manas. Now,
Reliance
prior
is
to
placed on the
introduction
law
of
of
this
speaker,
is very, very
where
important.
Deho the
Just
listed
kindly see
assembly.
this. Disqualification.
This evolution has been forgotten
Party
in
was
this
not a
argument of
member,
political
was
party
given the right
and
to maintain
legislative party.
disqualification. Prior
Well,
to the
this dissent point which your lordship put to me just now also,
did not
let me
mention
end on
political
that.
party
Just
anywhere.
see
Although
justice.
in parliamentary democracy, the heart, as your lordship has in the
Kyoto,
English
that
books,
para has been
is
read
political
one
party.
sentence. Read the
Westminster
whole
model
paper.
is political
Directly
party.
the point raised in
Even though
Kyoto.
political parties were always recognized to be an
The
essential
lordship should not be
component of
referring
the
to the
Westminster
Navambreva,
form
lordship
of
is
parliamentary
reconsidering
government.
Kyoto also on this basis.
Political party
Kindly
as
see.
a term was
This is a
defined
very important
for
para.
the purpose of
Para 49
election
at PDF
law
page
in para 2H
109.
of the symbols order.
Very telling para. Directly
Thereafter,
the
through
same
amendments,
sentiment.
the ROPA, the
How do you
Representative
harmonize the
Act,
two and you cannot
let us
allow
put
one to be
political
reduced to
party.
vanishing
They are the
point?
two statutory levels.
And I'll end
It
in about
came
a
in,
minute or 2
Malaz,
minutes.
for the first time with the 10th schedule, which is a constitutional recognition of political parties.
Indeed,
And
in a
today, Lordship has
sense.
been asked to negate that recognition.
Yeah, read this, fellows.
Next paragraph.
109. This is very,
On
very
the
important.
other hand,
The concept
it's a
of
covered
legislature
field. Your Lordship
party
need
has
not be
no
agonized
legal
about
or
it,
statutory
as my
basis.
learned friend would like your
The
Lordship to raise a
legislature
new
party
issue
by its very
before.
nature is not a
It's a covered
permanent
point.
association of persons. Its life is coterminous with the term of the
109
House.
PDF.
The very coming into existence of a legislature party is dependent on a contingency. The success of more than one candidate belonging to a political party.
We call
The
it, we used to
10th
call it
schedule
CL.
defines a legislature party in terms of a political party.
First time I found CA1 with this.
That is, fellows, conclusive, I say. According to me, I may be wrong. It's conclusive.
Indeed, in a sense, an anti-defection law is a statutory
party.
variant of its moral
I've quoted the
principle
definition.
and justification underlying
And
the
fellows,
power
your
of
lordship is
recall.
concerned with a whip.
What might
Whip is
justify a
peculiarly
provision
a
for
political
recall
party
would
activity.
justify a provision for disqualification for defection.
Kindly see the exact sentiment
purpose
which my
of
lord
defining the
expressed
group
to
of
me.
members of the House belonging to one political
Unprincipled
party
defection
as
is a
a
political
legislature
and social
party can
evil.
be gathered
It
from
is
the number of
perceived as
times
such
when
by the
legislative party is
legislature.
used.
People
First, in
apparently
2.1
have
it
grown
says a member
distrustful
of a
by
house
the emotive
belonging to
political
any political
exaltations
party.
that
What
such
does it mean?
floor
Do you have an
crossings belong to the
existence or
sacred
identity
area
other
of
than the
freedom
political
of
party?
conscience or of the right to dissent
After
or of
constitutional
intellectual
amendment
freedom.
and definition?
Can't be put better, Malas.
Then, Malas,
The anti-defection
there is no
law
mention
seeks
of
to
legislature
recognize
party
the
in para
practical
2.
need to place the
None.
proprieties of political and personal
In
conduct.
para 2, political parties
whose
mentioned.
awkward erosion and grotesque
Thus, while referring to
manifestation
individual members, the 10th
92,
schedule refers
I
to
don't
them
know
as
how much
political
more
party
grotesque
to
it
which
is
they
now to
belong and
remove.
not relation to legislative party.
Especially with the four-step procedure
The
here.
only place
Whose
in the
awkward
10th
erosion and
schedule
grotesque
where the
manifestation
term
will be the bane
legislature
of the
party
time.
is used
Above
was
certain
either para
theoretical
3 now
assumptions.
gone
Theoretical
or para
assumption.
4.
My learned friends have raised a theoretical argument.
In para 3, the term
which in
legislature
reality
party
have
was
fallen
used with
into
the
a
fraction of
morass of
one-third.
personal and political
Goes balance.
degradation. We
Four,
should, we
in
think,
para
defer
4-2, it is for
to this
merger.
legislative wisdom and
Doesn't arise
perception.
in this
The
case.
choices in constitutional adjudications quite clearly
Doesn't arise in this case.
indicate the need for such
Thus,
deference.
wherever the 10th schedule
Let the
provides protection
end
to
be
a group of
legitimate.
legislators when
Let
acting
operating as a group, the scope of the Constitution,
party.
and by all means which are appropriate, which are adopted.
Now, what is the
to that
consequence?
end.
This is a little important.
And here we
The
have added,
constitutional
I have
secret of
added,
this discussion is
for
that a majority faction legislative party
or
has no constitutional
mitigating
identity
circumstances.
except
You
for the
don't follow
purpose of
them,
setting up a
but you follow
defense
this.
under
This is
four.
extremely unfair.
This is actually, this is again like that technique of giving a notice to the speaker. It is trying to decimate the entire 10th schedule by saying dissent. Dissent has to be within the boundaries. But I'm extremely grateful. And
thank you, Doctor.
very deeply obliged.
Thank you, Doctor. Yes, Mr. Comment.
So I'll finish in 5 minutes, my lord. The 5 minutes left. Lords, I have put my thoughts in rejoinder in additional rejoinder A5, my lord, which is just a 5-6 page document. I have just 5 submissions to make. The lordships kindly have that. My lords, I had addressed your lordships on writ petition 479 of 2022, which was a challenge to the decision. Lord, that is A5. I'm sorry, my lord.
Right.
It's rejoinder, additional rejoinder A5, filed yesterday.
Yes.
Yes, ma'am. My lords, I had made submissions, my lord, only on writ petition 479, which is challenging the validity of the decision of the speaker on 3rd of July 2022. That is, my lord, the change of recognition from Sunil Prabhu to Bharat Gogavle late in the evening of 3rd July. Now, my lords, the validity of this decision is, my lords, unconnected with the ultimate, my lords, view which your lordships will take in the disqualification proceedings, whether your lordships want to decide it here or send it back. This, my lords, challenge is an independent challenge. Your lordships will have to determine whether the speaker was right or wrong. And the only defense which was taken originally in the reply was that it is 212. It is inside the house. And I had said that that is completely in the realm of unconstitutionality. There has been absolutely no rebuttal, my lord. That I have indicated in paragraph number 2, my lords, item 2. 3, my lords, I had submitted sub-Roman small 3, that the term political party is not an indeterminate, nebulous concept. Today, there are 30 people claiming, there may be more factions claiming that I am the political party. But on 21st of June, there was only one political party that was, my lord, in writing, which was communicated to the Election Commission, that was headed by us. Not with respect. This is not, my lord, a Narova Kunjarova. Lordships are aware of Mahabharat, my lord, that Ashwatthamo Hata, Narova Kunjarova. Whether they are Shiv Sena, we are Shiv Sena. In June, my lord, still they filed a petition on 19th of July. There was no dispute. There can't be any dispute in law that I represented the political party. So that's the second point which has not been answered as far as section 29A is concerned, my lord. Now, my lords, Mr. Sibbal has pointed out about the validity of the whip, my lord, and that only the political party can issue a whip, and that Erskine and May, all that was cited. And my learned friends have argued that no, it's the legislature party can issue the whip, Rule 3.1, etc. The lordships have seen Rule 3.1. Rule 3.1 does not deal with a whip. Neither the form deals with a whip. That is by convention. And in fact, affirmed by your lordship's judgment in Mayavati. Kindly have the highlighted portion, my lord. Paragraph 73 of Mayavati, reproduced in paragraph 3 here. Whatever direction is issued by the leader of such legislature party must be regarded as a direction issued by the political party. This was the argument. There is no merit in this contention when the provision in the Constitution has taken care to make a distinction between the legislature party and the original political party and prescribe that the direction issued should be one issued by the political party or by any person or authority authorized in this behalf. There is no meaning in saying that whatever the leader of the legislature party directs must be regarded as that of the original political party. This is Mr. Kaul's argument, my lord, specifically rejected. Now, my lord, all this parliamentary convention which we have set out in paragraph 4, my lord, has not been rebutted. Not even one precedent shown, my lord. Now, my lords, kindly turn to Roman 3. And this is a legal submission, my lord, that having a legislative majority ipso facto or ipso jure is not suggestive of a majority in the political party. My lords, Roman 1 and 2 have already been dealt with. Now, my lords, kindly have Roman 3. In fact, my lord, there are one-member legislature parties. And in those, my lord, circumstances and facts, Election Commission has said that we have to see the organizational majority to see who's the political party. So therefore, my lords, merely saying that you are a legislative majority and therefore you represent the political party is legally incorrect. Now, my lords, reference was made to Sadiq Ali, that Sadiq Ali, my lords, affirms this proposition. In fact, in Sadiq Ali, my lord, this point was kept open, and I have highlighted that, my lord. Kindly have a look at Roman 4, the highlighted portion. The present is not a case where a conflict has arisen because of one group having majority in the organizational wing and the other having a majority in the legislative wing. This has fallen for consideration here. Now, my lords, one submission was made by Mr. Jethmalani yesterday that, look here, we are also members of the Pratinidhi Sabha. Therefore, we represent the political party. Lords, on affidavits in the Election Commission and also here, for which there is no rebuttal, out of 220 Pratinidhi Sabha members, 160 plus, my lord, have supported me. 160 plus, not rebutted. Now, my lords, kindly see the next submission which is made. And this is again Mr. Jethmalani's submission, that Quixote said in paragraph 97 that the decision of the speaker is not covered by 212 and that the rules made under paragraph 8 have a constitutional status and therefore violation of that 2-day period or 7-day period is violation of the constitutional mandate. Totally against Ravi Nayak, my lord. Not even one judgment was cited in support of that submission, but kindly see Ravi Nayak, it's covered. Now kindly see paragraph 8, my lord, the highlighted portion. The disqualification rules are procedural in nature and any violation of the same would amount to an irregularity in procedure which is immune from judicial scrutiny. Then, my lords, I just have 30 seconds, my lord, I'll just finish, my lord. My lords, then a reference was made to some speeches, my lord, that I have dealt with. Lord, some speech of some DG is totally inadmissible. My lordships have held it time and again, which your lordships have seen in Kalpana Mehta Constitution Bench and also in Shivraj. Speeches by, my lords, members, totally irrelevant, my lord, to decide what the scope of the provision is. Yes, my lord. Then, my lord, para 6, they said that mere non-attendance of a meeting will not amount to a para 21A. Specifically, my lord, this was the issue in Sriman Balasaheb Patil. One meeting they didn't attend, it was held to be a para 21A, which I have reproduced, my lords, in paragraph 14. Now, my lord, the last thing is important. Kindly have paragraph 15. My lords, time and again, my learned friends, my lord, said that we have never claimed a split. In fact, I remember, my lord, Honorable Justice Kohli asking Mr. Kaul, is it your case that there is a split? And he said, on more than, my lords, 5 occasions, which I have reproduced, kindly see this. First, our case is not a split at all. I have never argued I have a split. Now, kindly see the submissions before the Election Commission. And now the cat is out of the bag. Please have a look at paragraph 16, my lord, of my note. And I've reproduced paragraph 7 of their petition before the Election Commission. In view of the above mentioned facts and circumstances, it is evident that there is a split in the Shiv Sena. And all the written submissions filed by Mr. Mahesh Jethmalani and Mr. Shinde, my lords, categorically say there is a split. I have pointed that out, my lords, in paragraph 17. To come here, my lords, and say that we are a faction, we represent the political party, is only sugarcoating, my lord, the factum of a split. Lords, lastly, my lord, ultimately your lordships will decide. Lords, I am reminded of a, my lords, Sanskrit Subhashit, my lord. And it says, my lord, Kakaha Krishnaha, Pikaha Krishnaha. That, my lord, the crow is also black, the cuckoo is also black. Ko Bedaha Pika Kakoy. What is the difference? Who's the Shiv Sena here? Vasanta Samaye Prapte, Kakaha Kakaha, Pikaha Pikaha. And I'm sure, my lords, the time of judgment will be clear, my lord, who's the real Shiv Sena. Thank you so much.
We'll be failing in our duty if I don't mention that the assisting councils, my lords, on both the sides did a phenomenal job in assisting us. And very grateful to your lordships for all the time.
Our compliments to you for
Yes.
Yes, my lord. Rohit Sharma is here.
Valuable assistance.
our compliments
On the sides, my lords, they did a phenomenal job. We could not have argued this without their
to
assistance.
the juniors is also
Yes.
to
We are
Very grateful, my
very
lords, for all the
patient
time that your lordships gave us. For all the time that your lordships.
we'll
Grateful,
reserve
my lord.
judgment.
Grateful.
Very, very grateful.
Every business is like a complex mechanism with a lot of moving parts that have to work in perfect harmony with each other. If one of the parts starts to malfunction or simply doesn't fit, it may cause the whole thing to fall apart completely. Bittrex 24 is an all-in-one solution that effortlessly combines dozens of tools. It's an online workspace that features CRM, tools for project management, collaboration, e-commerce, business automation, and more. All cross-integrated and working perfectly like a well-oiled machine. Free for unlimited users. Get now for free.